SJC-12290, Commonwealth v. Jeremy D. Gomes.
Mr. Hirsch, good morning.
Good morning. If it please the court, Mr. Chief Justice, in Mr. Gomes' direct appeal, this court held that the issue was not whether the judge had the discretion to give the proffered instruction, but whether he abused his discretion by refusing to do so. And you, of course, ruled that he did not because he gave the instruction that was proper at the time. We have a different issue today, and that issue is whether justice was done, whether we can have confidence in the verdict, whether there's a substantial risk of a miscarriage of justice. The conviction here was based...
Isn't the issue whether counsel was ineffective, or are you broadening it?
Your Honor, there are two possibilities, ineffectiveness or, under the new Brescia-Epps standard, the mere fact of lack of confidence in the verdict of whether justice was done is enough. And I understand that's to be used sparingly, but I think it affects this case here. The conviction here was based entirely on the identifications, and the identifications were exceptionally unreliable. Under Epps, the touchstone is to do justice, and under Epps, in all the cases I've cited, I think that requires reversal here. One issue that arises here is whether this is still ineffectiveness, given that this was not the law at the time, that the Gomes ruling was not the rule at the time. I think it is. I think there's a tremendous distinction between this case and various others where this court has decided that counsel could not be faulted for failing to raise something that was not yet the law. Here, counsel did raise it. Counsel raised it based on the precedent from New Jersey, Henderson. The problem is, as this court found, counsel didn't do enough with it. Counsel didn't do enough to support it. Counsel could have brought in cited scholarly articles, could have brought in an expert, either. And this court found, because counsel didn't do that, the judge did not abuse his discretion by refusing to give the instruction. If that's the reason, then if counsel had done enough to support this request, the judge would have abused his discretion by denying it.
But the attorney did more here than any of the very zealous, talented attorneys ever did in an ID case before Gomes in front of me.
Your Honor, I think in large part, the attorney did an excellent job. But if you make one error that's sufficient to meet the Severian standard, it's ineffectiveness. And that was, I'm citing this court's language for why the judge did not abuse his discretion. It's because she didn't support it enough. Ergo...
Well, it's also because there was an instruction of this court which has been adopted by the court in Rodriguez. I mean, you're dealing with an instruction which this court had adopted in the Rodriguez case.
Well, yes, and for that reason, it was not a violation, an abuse of discretion, but that doesn't change the fact that this court said it was not an abuse of discretion because she didn't support it. Now, not only that, as I just mentioned before, following Brescia and Epps, it need not be ineffective assistance of counsel. If the various things that happened, whoever's to blame for them, or if nobody's to blame for them, kept there from being justice we can count on in this case, there must be dismissal. And all of the reasons this court gave in Mr. Gomes' direct appeal for insisting in the future, on these new instructions. All of them apply so strongly here. We have the issue of confirmatory feedback. We have the issue of Mr. Wilson claiming to have seen this man at another time, but not nearly at the level suggested for familiarity in the Johnson case. Any and all of these things may well have changed the verdict in this case, and I don't think that can be ignored. Brescia says it best. The fundamental principle established by Rule 30B is that if it appears that justice may not have been done, the valuable finality of judicial proceedings must yield to our system's reluctance to countenance significant injustices. So why didn't this court take the step in Gomes of remanding on the basis of Brescia and Epps? Why didn't this court order a new trial? The only reason I've been able to come up with, and I'm certainly not privy to the court's thinking, the only reason I've been able to come up with is that trial counsel, however well she did in other respects, didn't fully support that her request for the Henderson-type instruction, and therefore the judge didn't abuse his discretion. I could think of no other reason. But when we look at this case, well, let me switch to another part of the argument here, the claim that this was a tactical issue. First of all, counsel said it wasn't in her affidavit. Second of all, there's nothing to gain from it. My brother has listed items from her opening and closing on pages 22 and 23 of his brief. They're all consistent with a Henderson-type instruction. They wouldn't interfere with it. They wouldn't collide with it in any way. Third, she asked for it twice. First, she asked for the instruction, and then she objected when the judge didn't give it. That's not a tactical decision to not try to get it. That's not abandonment. That's, as Justice Lowy was saying, somebody who's trying really hard to get the court to use it. Finally, the Commonwealth writes, my brother writes that the tactical reasons for not calling Dr. Summers to testify in the trial are the same tactical reasons that trial counsel thereafter had to not submit treatises to the trial judge as a foundation for trial counsel's requested jury instructions. I do not understand that, because whatever danger there might have been in calling Dr. Summers, and I really don't think there was any, there is no danger at all in presenting these various treatises that I've cited, these articles, all of which support the notion that these were not valid IDs. The fact that an expert wasn't called is irrelevant in this case, because even if there was some danger in calling him, even if there had been, there was no danger from getting the instruction based on the treatises. In the Rivera case, this court said that, well, going back to Mr. Gomes' direct appeal, this court said that the instruction was not erroneous, but at worst, inadequate and incomplete. The question thus becomes, how did that inadequacy affect the trial? Well, in Rivera, the appeals court said the test is whether the inadequacy of the instruction was likely to have influenced the jury's conclusion. I think that's very clearly the test that applies here, and one that mandates a new trial for Mr. Gomes. The more we look at these instructions, the defect at these identifications, the defects in them, the things that were left out, the things the jury didn't learn about, certainty, identity transference, all of those things, they never heard about. How would they have resolved this case had they heard about them? It's a very good chance it would have been differently, and on that I'll rest, absent other questions.
All right, thank you. Mr. Calaflores, it's now good afternoon.
Good afternoon, Mr. Chief Justice. Joseph Calaflores for the Commonwealth, Berkshire District. When we're looking at this case and whether or not, we have to understand that there is kind of this lattice work of standards that we will be applying to it. Brescia and Epps do put whether or not justice was done, but at the same time we are confronted with a Safarian standard where we both have the reasonable attorney and then prejudice. When taking all of this lattice work of standards together, we've got to look at the procedural history to fully understand how this laid out. The State v. Henderson out of New Jersey came out in 2011 and was presented to the trial court, the trial judge, approximately a week before the trial commenced. The study group here in Massachusetts did not come out until July 25th, 2013. And of course, Mr. Chief Justice, you issued the opinion in Gomes 1 in 2015. Later on, we had the motion for new trial, and we have found ourselves here again today. When looking at that procedural history, we have to understand the trial judge, when presented with a Henderson request for that instruction, was faced with an out-of-state, extrajudicial instruction a week old, where we had a Rodriguez instruction that was judicially approved here in Massachusetts. At that same time, Brother Counsel looks at the opinion written by Mr. Chief Justice that it was not an abuse of discretion where there was no presentation and there was the judicially approved Rodriguez instructions. And I would argue that even if trial counsel was able to, or did in fact, produce further treatises in support of her request, which was very ahead of its time, the trial judge still would not have abused his discretion in denying it. There was no study group. I'm not positive if it had been established at that time, but it wouldn't come out for another 2+ years. Without the help of the study group, the judge did not err. Now, under the ineffective assistance of counsel claim, we do see that trial counsel did push the issue. She requested it, and in fact, she did receive permission to call an expert witness. She would have been able to lay that groundwork. The Commonwealth puts the argument out that it was not ineffective because it was a strategic decision to not call that expert or to not propose treatises in support of her jury instruction. Now, that is because store clerk Wilson is familiar with the defendant. He states at trial that he is familiar with the subject. He had come into the store numerous times. Now, on September 15th, store clerk Wilson, that's 5 days after the incident, went to the police station and combed through over 900 images and picked out the defendant. Now, in looking at everything, we also have to understand that the victim, and he went through a later reduced amount of photos, and although unable to pick out the defendant, said, if I had to pick somebody from this array, it would be the defendant. Now, when looking at that, I think that shows the adequacy of the identification of store clerk Wilson. And the instructions, and Brother Counsel mentioned in his argument, that the opening and closing arguments regarding identification mirror that of Henderson. The argument that it was a misidentification was well presented to the jury, and at the time, the Rodriguez instruction, while not as great as they are now, today, were era appropriate. When we're looking at the ineffective assistance of counsel claims, we're not to look at it in a hindsight of 2020 from the current standard, but rather at the time that the decision is made. Whether trial counsel was making a strategic decision at that time, given the fact that Henderson was out of state, there was no study group, and that there were judicially approved Rodriguez instructions here in Massachusetts. I'd like to distinguish a few of the other cases that the defendant cites in his brief. All the other ones applying retroactively certain new standards They all relate to the admission of evidence. The Creighton case is the admission of an in-court identification where there is no out-of-court identification. Once again, those are all evidentiary matters that I think are inapt to be applied to here, where we're not discussing whether or not something is admitted at trial, but simply whether or not there were proper jury instructions. And once again, I stress, Rodriguez was era appropriate.
How do you address the Brescia-Epps argument that your brother makes?
On whether or not justice was done under Brescia and Epps, I think that standard, whether justice has been done, has been rooted in Rule 30 for quite some time, and we've kind of put it to the forefront as well in the lattice work of the standards that we must apply now. And whether or not justice was done here, I would argue, again, it must be applied not in hindsight 2020, but at the time of the decision, at the time of the trial. When we're looking at the time of the trial, justice was done. Trial counsel made a good pitch for a new instruction, which would inevitably become the standard for the new post-Gomes identity instructions. But justice was done where the Rodriguez instructions were judicially approved and were properly given. Indeed, the opening and closing arguments, while they mirror Henderson, they also do apply to the Rodriguez instructions in that it can attack certain factors in the identification by the witnesses.
In the motion, I see the judge did not address, I guess Brescia was out. I'm not sure whether Epps was out before the judge ruled. Both were 2016, so I don't know. Was there any argument before the motion judge that, wholly apart from counsel being ineffective, that the result was fundamentally unfair and a miscarriage of justice?
I don't recall off the top of my head or the argument. The argument was a little disjointed. It was via teleconference. There was a moment where it kind of fell off, and I lost counsel who couldn't hear us while I was talking. And then I ended up sitting next to the judge so he could see me properly. But the argument there was really whether or not, yes, whether there was justice was done, but whether or not Mr. Chief Justice, in your opinion, would have deemed it necessary at the decision in Gomes 1 to send it back for a new trial with the new Gomes instructions. I noted in my opposition to the motion for new trial, and I believe I've noted in my appeals brief, that in Gomes 1, the defendant did request a remand for a new trial with the requested instructions. And the court, Mr. Chief Justice, and the panel decided that it was not necessary. And in the opinion, it specifically states that it is a prospective-only rule, jury instruction, to be applied to cases starting after the issuance of that opinion. So based on that ground, I argue that because the offer of a new trial was requested at the SJC, it's not the position of the trial court to second-guess that when the request has already been made. In the Commonwealth's view, what is essentially happening here is this is almost a second bite of the apple where there's a denial of the jury instruction in Gomes 1, where there's not an abuse of discretion, whether it's the and statement of where there's not the request, the proffer of the treatises, and there's the Rodriguez instructions. The defendant now is taking that Gomes 1 decision and kind of flipping it on its head, splitting it out and said where there's no treatises, it is necessarily an effective assistance of counsel because if it had been given, it would have been an abuse of discretion. But I defer to the actual text of the opinion where it is the and statement. It's both the treatise absence and the presence of the Rodriguez instructions, which meant that it was not an abuse of discretion at that time. Here on a motion for new trial, Rule 30B, once again, we're here in a motion that is best left to the discretion of a trial judge to determine whether or not justice was done. And looking at the totality of the circumstances, the timing of Henderson being a week before trial, the study group not coming out until July 25th, 2013, a little less than a year after the trial, the judge would have not abused discretion even if he was afforded the opportunity to read additional treatises. He had the approved of Rodriguez instructions at that time. If there are no further questions, the Commonwealth would would rest on its brief.
All right, thank you.
Thank you.